Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Pereira. The government plans to bring a digital payment bill to strengthen legal framework and enhance surveillance to check cyber crimes in the financial sector, including frauds targeting cards and e-wallets. The feasibility of such legislation, according to media reports, was discussed during a meeting chaired by Union Home Minister Rajnath Singh on Tuesday. According to reports, on inter-ministerial committee headed by the Home Minister will first study existing laws to deal with cyber crimes and then propose legislation. The need to do this was felt after a spurt in the number of complaints, especially after demonetization. The proposed legislation will not only deal with punishment and fine for those who dupe online users, it will have measures to fix responsibility in cases where digital transactions land in any dispute. On this edition of The Big Picture, we will analyze the government's plan of bringing a bill to tackle cyber crimes. Joining me on the program today are Virag Gupta, cyber law expert and advocate of the Supreme Court, Satya Prakash, legal editor of the Tribune, and Deepak, advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. Virag Gupta, I'd like to start with you. Do you think it's high time that we come up with a new cybercrime bill?
It's high time, and the problem is that one for digital matter, already one committee is there, Justice Sri Krishna committee is there. And there was 166A law was there, which was quashed by the Supreme Court, and that is also under the process. Problem is there are many stakeholders are there, like SEBI is there, RBI is there, then the in-government Home Ministry and other security agencies are there. That how to frame the law and how to enforce is, that is the bigger challenge. Because let's talk about the blue whale, that's a bigger challenge. Government has issued one circular to the social media companies. Now they are not complying. In the Delhi High Court, they said that we are not concerned about this. And on the same day, they launched an application, Google launched application in India, and we don't know that who are the stakeholders and who are the companies to whom we have to enforce the law. So there are the three challenges. Number one challenge is that under which law you have to make the necessary changes, or you have to bring a new law, and especially after the privacy challenge is there. Second is the different stakeholders, and third is even if you have the law, then how to enforce with the technology companies. I think those are the bigger issues.
You know, Satya Prakash, do we have the wherewithal to deal with cyber crimes on a whole?
As of now, no. Because in the last 3 years, more than 1 lakh cyber attacks have taken place. Besides, even the legal framework, it's not good enough or robust enough to take care of all these things. So first thing, the government has to be congratulated for the fact that they have started taking steps for beefing up the entire cyber security setup. In recent past, what has happened is, it is not that we are talking about 90s or 80s. We are in 21st century and 2017, and this is post-monetization. There is a push towards digitization of everything. So all the government documents, even bank, RBI details of everything, financial details, RBI, SEBI, or all the stock exchanges, individual bank accounts, everything is held electronically. So electronic transactions are taking place in huge numbers, and there is a government push from the government side also. So in this scenario, it's all the more important that we beef up the entire cyber security setup. The problem is there is always a gap between technology and law. Technology changes very fast. Law takes its own time to change, and that gap creates problems, and that is the area where the the antisocial elements, or rather criminal elements, they take advantage of that, and then people are fleeced in that way. The need is to bridge this gap between law and technology. The government has thought of it, it's good, but they must be fast, because by the time they come up with the law, the technology might change and something might happen. So this gap will remain there, but still we should be taking steps at a very fast pace, because the way we acted in the past is not going to serve. And second point is, while drafting laws, we must take care of certain things, because in the past what has happened is we drafted law, and then like 66A was struck down by the Supreme Court, and there was complete, I'm sorry to say, there was complete non-application of mind. On December 22nd, 2008, that IT Act Amendment Bill was passed by the Lok Sabha. The very next day, on December 23rd, 2008, it was passed by the Lok Sabha, and literally without any discussion. In such serious issues, there should be some discussion in Parliament, or not some, there should be substantive discussion in Parliament. Unfortunately, most of the times, that has improved in the recent past, but we have witnessed acrimonious scene over some political issues, and then the entire Parliament session is washed out. That should not happen. At least in such serious matters, there should be discussion before a law is passed.
Sure. You know, a very valid point there raised by Satya Prakash, Deepak. You know, technology is fast advancing, but our laws just seem to be, you know, failing to catch up with technology, and something needs to be done at the earliest to address that particular problem. The IT Act, of course, was passed by Parliament to deal specifically with cyber crimes. But what are the drawbacks, if I could call it drawbacks, or should I say challenges as far as the IT Act is concerned?
See, first of all, I must agree with almost everything that Mr. Satya Prakash has said, because he has hit the nail on almost everything. See, one of the things is it's going to be always a catch-up act for law as far as keeping pace with the technology is concerned. That only means that you need to stay abreast of what's happening, receive feedback from the stakeholders, which would mean the industry, understand that, and see what you can do to strengthen that feedback mechanism and have some kind of a nimble system wherein this can be crystallized as some kind of a legal remedy, perhaps by way of rules, if not always going through the legislative route where you have to, let's say, legislate an act or to amend an act. That's a huge process. That's one. Second, the IT Act must be understood as a seminal legislation from the standpoint of recognizing online transactions, which is what it was meant to do in the first place, giving legal sanctity to something that is exchanged over emails and whatnot. So from that standpoint, as far as crimes online are concerned, or cyber crimes are concerned, was perhaps just one of those aspects that the IT Act dealt with. And I don't think it has proved itself to be entirely useful in that regard in being able to address everything. Be that as it may, even on those rudimentary aspects which the IT Act addresses, to answer your question of wherewithal, we don't seem to have the resources needed to address even those rudimentary aspects from an enforcement standpoint. So one is law having to keep pace with technology. Second is law enforcement having to keep pace with law and technology. So this is another aspect that we need to focus on. And I gather from a news report that one of the elements that the government is focusing on is capacity building in this particular regard, which I think is the most important thing. See, let's assume that you come out with a specialist legislation which is at par with any other legislation on the same topic in perhaps the most advanced jurisdiction in the world. To what end? If people don't know what to do with it, and people who are supposed to implement it, people who are supposed to wield it, and people who are supposed to take benefit of it don't know how to use it, then what's the point? So there is a huge fall between the pace at which the industry moves and the pace at which law enforcement moves, and the pace at which all of this translates to some kind of an understanding in courts and from the judiciary. So as far as I'm concerned, there's a lot to be done apart from having a specialist legislation, because the easiest way to address a certain problem these days can be to say, let's come out with a special legislation for it. Why? Do you need a special legislation? Is there a way of addressing all these concerns as part of the IPC and the IT Act by making a few changes and by ensuring that this law remains valid at least for the next 5 or 10 years and then you revisit it later? Because each time you come out with a specialist legislation to address a new problem,
there's going to be another new problem that
exactly.
arises.
And perhaps it helps lawyers and litigators, but I'm not sure it really helps the litigants. And importantly, you end up saying that this always and by default at the very outset deserves a special treatment. You need to justify that special treatment. You need to give reasons for it. So yes, you need to keep pace with it, but we must also ensure that it doesn't become another piece of legislation where every few years you have an amendment to fix new defects.
Sure.
At least think through, make sure that the legislation is valid enough for the next 5 or 10 years and then revisit it later. But as I said, I think capacity building is something that we need to focus on, because if you're not good at 101, I don't see how you're going to go to the next level.
Okay, capacity building is what we need to focus on. What else, Virag Gupta, needs to be done to fill or plug the loopholes in the existing system?
No, there is one thing which Satya Prakash ji has said, that gap of technology and law. But there is one more aspect is there, and that aspect is non-applicability and non-enforcement of the existing laws. Let us talk about the SEBI and the RBI rules. Now, as per the existing rules of the RBI and the SEBI, you can't have any financial transaction management company without getting license from them. Suppose WhatsApp tomorrow want to start some financial transaction business model. So, for that, I think that as per the existing law, they must take license from the RBI. And once they are getting the license from the RBI, then they will have to create other mechanism also, that they will have to establish one company in the India, so that they can take the accountability. Then they should be duty bound with the KYC norms. Now, these laws are there. The problem in our country is that we feel that digital platform is beyond law. It happens in the 66A matter also. What happened? 66A was not a new law. It was simply a bridge between the IPC and the IT Act. Now, 66A was struck down. Now, what happened? That the police and enforcement agencies are misusing the IPC provisions. So, what happened? That once you have laws like this censor board is there. Now, the censor board laws, why should not they be applicable in the YouTube and other platforms? So, these things, various laws are there, various regulators are there. Then comes the issue of telephone and the cyber. Now, we have the TRI, then we have the other regulators also. So, who can take the consolidated position to regulate both the platforms, because both are the interlinked. So, what today is happening, we are seeing from the security point of view. What 1 month back we have seen it from the perspective of the consumer and the data protection of the privacy law. But we need to have the holistic approach about the whole problem, I think, in which previous government failed. This government is working, but they have to act fast.
Okay. Action is needed, and action is needed at the earliest is what you're suggesting. You know, legislation, Satya Prakash, is just one aspect as far as cyber crimes are concerned. There are so many other aspects involved when it comes to cyber crime. So how do you deal with cyber crimes on the whole?
See, it's very difficult. This particular law we are talking about, which is yet to come. In the first place, IT Act, which came in 2000, it was not the initiative of Indian government. Why it came was, there was an initiative taken by the United Nations, and UN General Assembly had passed a resolution in 1997 or 1998. And then there was requiring the member states to enact laws in accordance with the model law that they provided. We enacted that law. Purpose was to facilitate electronic commerce and also e-governance. The third part was to punish those who violate this law. The problem is we have not gone beyond that. Whatever was the basic law, that was the model law was provided. We have, because since for the last 20 years, a lot has changed in the cyber world. We need to update our law. So government initiative is good, but then what all changes are needed? One aspect is like cyber crime. Crime is, it can be a financial crime, it can be any other crime. The Supreme Court is dealing with a public interest in a litigation filed by an NGO, in which they are trying to block the rape videos there is a huge number of rape videos circulated online, and this PIL seeks to block that. And all the social media platforms, Google, Yahoo, Facebook, they all have been invited by the Supreme Court, and they are part of a committee set up by the on the orders of the government, on the orders of the Supreme Court, and the government officials are also part of that. They are trying to figure out how to block this video. So it's a very serious issue and a very complicated issue from technology standpoint. What is needed is, while drafting these laws, there should be proper input from industry experts, those who know technology side of this law, because this is not a simple IPC or simple CRPC procedure or something. This is where, if you don't know the technical intricacies of the issue, most need to update the law as and when the technology changes, because and then while changing also, we need to be vigilant about the requirements, and there are other requirements also, constitutional requirements, because without proper vetting by the law ministry, the law, you enact a law and it can be struck down. What happened in 66A case?
Sure. You know, there's a lot spoken about what needs to be done, and we're speaking about this proposed law that is to come up as well. But there are limitations as far as this proposed law is concerned too, Sai, because it's talking about digital payments and it's also talking about only the financial aspect of it. What about the other aspects of cyber crimes? Are those going to be neglected?
See, that's I think it's a fantastic question for the simple reason that your reaction shouldn't guide the framework of the particular legislation, because each time you respond to one particular feedback that comes from one sector or one particular industry, then it's a very truncated vision, it's a very narrow vision, and that's not the way to go about it. See, let me answer this question. It's like this. Let's assume the legislation comes with respect to financial crimes, or let's say crimes in the financial sector. You have to understand that what we are essentially dealing with is information that will automatically translate to enhanced obligations on people who are storing that information. And these people by and large could be intermediaries, non-intermediaries within the meaning of the Information Technology Act. That means there will be increased responsibility with respect to encryption, whatnot, so on and so forth, that translates to costs. Plus, what kind of obligations do you cast on them if they're supposed to cooperate with investigation as and when an offense is being investigated? All these aspects are extremely complex, and more than being complex, they are subject to you understanding how the industry works. That's one. But then, as you rightly said, you can't limit yourself only to this tunnel vision of one particular industry, which is why I have a problem with a special legislation that deals only with cybercrimes in the financial sector. Why does it need to be deserved at a different level altogether? Why not address cybercrimes in general? If you believe that the existing legislation such as the IPC or the IT Act has a problem or it has a certain defect, and that you have to deal with it as a sui generis thing, address cybercrimes holistically at least, as opposed to cybercrimes for a particular sector. There's a problem there. Second, I say this having been part of the Shreya Singhal decision. While there were a host of petitioners who challenged Section 66A, I was part of the team that represented the Internet and Mobile Association of India, where the problem was with the overreach through Section 79 as far as intermediary liability was concerned, where the manner in which it was being interpreted and enforced was very, very onerous from an intermediary standpoint. So, Justice Nariman had actually authored that particular judgment, a brilliant judgment. He had actually come out with fantastic points, and that particular provision, Section 79, was read down. If not struck out completely, it was at least read down to some extent. Despite the decision, you find multiple cases going on in several courts in this country where intermediaries are still hauled up for no fault of theirs, when their status as an intermediary is accepted and admitted. What this tells you is, the law may say something, the Supreme Court may say something, but its application by high courts or by law enforcement agencies may be at variance with what the law intended and how the Supreme Court interpreted it. So sometimes in our lofty, let's say, journey of interpreting free speech, privacy and all that, the Supreme Court may come out with a beautiful judgment running into several hundred pages. But what does it actually translate to the constable wielding the lathi on the ground? Right. That's the question, because that is the law. Sure. What the Supreme Court may be the law in theory, but how it is applied by the constable on the street or anybody, the beat police guy, is the law. So can we try and address this gap is something that I think we must try and focus on if we are embarking on this process.
Sure, yes.
After Supreme Court judgment, in spite of Supreme Court judgment, many police officers lost the FIR under 66A. That's the problem. Correct. Now we are discussing about law only. We have the two biggest problem. Number one, who is going to enforce the law and against whom? He has rightly raised the issue of the intermediary. Now let me give the three instances. Number one instance was Uber gang rape, Uber rape matter. After that, Delhi police was not able to locate the office of the company. A company which is running the biggest taxi network in India, they don't had any office at that time. Number two was a matter when the Google Earth, they were doing the Google mapping and everything, and CBI lodged a complaint, and after that what happened, I don't know, but how they got the permission. And RBI noticed many instances where these companies were not complying with the RBI guidelines of the double authentication. Now these type of violations are being noticed by the police, intelligence agencies, enforcement agencies, SEBI, RBI and other regulators. Problem is against whom you can enforce these laws, because the companies who are doing business in India, they are saying that we are the US companies or Singapore companies, the Ireland companies, company which is in India, they say we are the simple intermediary company or we are the marketing agent. So ultimately, even if you make a new law, against whom you are going to enforce, that is going to be the biggest challenge before the government and the law enforcement agencies.
Okay, sure, fair. Yes, sir.
I'll just make one point. If you deal with any of these companies who deal with cyber issues on a regular basis, who encounter it, and you give them two options, will you explore the criminal remedy or will you explore the civil remedy? By and large, they'll opt only for the civil remedy because of the very hassle of having to educate law enforcement agencies on the technology, on the issues, so on and so forth. And they'll say, I don't mind going through the delay of a civil litigation before a court of law in this country, as opposed to having to put myself through the hassle of a criminal inquiry, because half the time I have to educate people. They don't seem to know what they're supposed to be doing. So this needs to be addressed at some point, because you may have a fantastic structure in theory, but if it doesn't work on the ground, then it is as good as non-existent.
Yeah, application is very, very important.
Enforcement is our Achilles heel.
Yeah, true. Satya Prakash, as far as cyber crimes are concerned, there are several other major cyber crimes that happen all across the world, in far more developed countries. Clearly, they too are dealing with the same kind of problems that we have here, maybe on a larger scale. So is there some kind of a best practice that we can, we can take from them and employ here in India?
Well, that will be very difficult because of the nature of the entire setup and cyber security. So, because if you try to take something from somewhere, that may not fit into your requirement. It depends upon because here sometimes somebody who is using something would be somebody in a village who is not that well educated. He may not be knowing that much about cyber security. So here we have to design something, draft something, and prepare something which can be used by a common man. Even the government releases the money under DBT, direct benefit scheme, transfer scheme, directly into account of the beneficiaries, and now we are pushing everybody to use cyber technology and go digital. So here, given the fact that majority of the people, they may not be that well versed in technology, our challenge is slightly difficult. So we need to customize our own, whatever we are preparing, it should be customized to the for a better use by a less allocated gentry.
Sure. Yes, Virag.
We are the biggest retail destination as per the yesterday's report. America has very strict laws, and European Union also. Now you will see that European Union has imposed many big penalties against these defaulting companies. In USA, these companies, many of the 9 companies were involved in the PRISM, and they shared many crucial information with the US intelligence agencies. And as per yesterday's report, 2005 India's missile program data was there with the US, and these were shared by these companies. What happened? Unless we have the law, unless we impose the heavy penalty and prosecute them criminally, till that we will have little respect for Indian laws.
Okay. Should accountability be fixed as far as dealing with, cyber crimes, cyber crimes are concerned? Because somehow it seems like we are not too serious about cyber crimes. And is that really a problem?
See, the thing is, accountability in the name of it being fixed is typically laid at the doors of one entity which is typically made out to be the villain. And then it is hailed as a revolutionary piece of legislation. So as opposed to, let's say, demonizing or vilifying one particular segment of the industry, we must see how is it that each stakeholder in this entire value chain can be held responsible for the actions that they initiate or they are responsible for, apart from also holding enforcement agencies accountable to some extent for lack of enforcement. What mechanisms or what remedies have you given to a common person when, let's say, a cybercrime, let's say, complaint is not taken forward? For how long will he continue to languish? For how long will that complaint be in the cold storage? So that kind, each time if I have to go to the high court or whichever court to actually get some kind of a remedy, then you've made a mockery of the trial court in the first place. You've made a mockery of the court of first instance. The court of first instance in most advanced jurisdictions is more or less the best forum and the final forum as far as fact-finding and decisions are concerned. And for that to happen, investigation agencies and trial courts, those processes will have to be strengthened. Only then it gets a certain amount of respect. And then you can avoid any further appeal. Otherwise, any legislation could translate to protracted litigation as opposed to putting an end to that particular issue. So going back to the topic, accountability not just on members of the industry, but equally on members of the establishment, ecosystem, enforcement agencies, courts.
Sure. And as far as individuals are concerned, Satya Prakash, do you believe that there is enough awareness, to deal with cyber crimes or, to deal with the problem of cyber crimes? Do you think that, individuals need to be made more aware?
In fact, even students who are school-going students who are using mobile phones, they should be educated about cyber laws. and do's and don'ts of cyber world, because they are the ones who have started using mobile, started using internet. They are not aware about intricacies of the crime side of it. So inadvertently they might do something and land in trouble. So it's important for us to educate them. So cyber education should start in schools, and then of course in colleges, and as we get into the professional world, we should be getting ourselves updated about changes in the law, changes in the technology, and the pitfalls of the technology and law. Otherwise, many people will fall foul of law without any reason and without having there any intention to commit crime. So it's important for us to educate people so far as this cyber law and cyber crime is concerned.
Okay, quick closing comment.
Only one thing is there, that as per the IT intermediary rules and as per the Delhi High Court order in the Govindachar matter, court has directed for appointment of grievance officer by all these internet companies. If they do appoint the grievance officer, they do circulate the toll-free number and the contact details. I think it will help a lot to the police, investigating agencies and the common public for the grievance, so that as per existing laws they can get the relief in the cyber crimes.
Okay, fine. On that note then, I'll have to call it a wrap on this edition of The Big Picture because we are out of time today. I'd like to thank my guests, Virag Gupta, Satya Prakash and Deepak for joining me on the program and putting things into perspective for us. That's all the time we have today. See you again next time.